So let's take on three quick updates. First, Judge Aileen Cannon grants Donald Trump's request for the appointment of a special master. Second, the FBI searches Barron's bedroom. And third, the continued inaction by the Department of Justice. Let's tackle these three stories, because justice matters. Hey all, Glenn Kirshner here. So let's take on three quick legal updates, and the first one is a big one. We just learned that a federal district court judge, a Trump appointee, Judge Aileen Cannon, just granted Donald Trump's request that a special master be appointed to review all of the documents that were seized pursuant to a judicially authorized search from Mar-a-Lago. And this one, friends, is hot off the presses. I've just read a short summary of the judge's opinion. I have to digest the entire opinion, so please bear with me. This will be a little bit of a stream of consciousness video, but boy, I've seen some things that leave me troubled. First, let me read the short summary of Judge Cannon's ruling. The court hereby authorizes the appointment of a special master to review the seized property for personal items and documents and potentially privileged material subject to claims of attorney-client and or executive privilege. Furthermore, in natural conjunction with that appointment and consistent with the value and sequence of special master procedures, the court also temporarily enjoins the government from reviewing and using the seized materials for investigative purposes pending completion of the special master's review or further court order. This order shall not impede the classification review and or intelligence assessment by the Office of the Director of National Intelligence, ODNI, as described in the government's notice of receipt of preliminary order. Okay, friends, that's a mouthful. Let's try to unpack it, and then let's hit the highlights and the lowlights. First of all, the Department of Justice and the executive branch will now have some tactical decisions to make. Does DOJ appeal this order, or do they let it stand and try to comply with it? I suggest they should appeal it. It is of dubious legal authority. And here's the problem. If they don't appeal it and they let it stand, it will be viewed as precedent. It won't be actual precedent, because trial court judges don't set precedent, only appellate court judges do. But what they do is they set what I call atmospheric precedent. In the future, other people will point to this and say, hey, Donald Trump got a special master. DOJ just searched my place. I want a special master too. It's not legal precedent, but that kind of argument can carry some weight. It can be somewhat persuasive. So I think that's one reason the Department of Justice should seriously consider appealing this to the appellate court, and then we'll get some precedent on the issue, actual legal precedent. The second thing that really troubles me is that the judge ordered the Department of Justice to stop dead in its tracks its criminal investigation based on the documents that they seized, documents that Donald Trump stole from the federal government and unlawfully concealed at Mar-a-Lago. Why is that such a big deal? Why is that so potentially damaging and dangerous? Here's why. Let's assume that as the FBI agents and the federal prosecutors working this case have been pouring through the thousands of documents Donald Trump stole, many of them highly classified, many of them having the potential to compromise our national security. Let's assume they've already taken all sorts of investigative steps. I would assume they have. For example, they may have found documents in there that led them to issue subpoenas for other witnesses. And those witnesses maybe are scheduled to appear before the grand jury tomorrow. Does that mean the federal prosecutors have to withdraw those subpoenas? Stop dead in their tracks on the investigative work they're doing. Let me use another example. Some of these documents, I would bet, are being forensically tested. When we get documents as evidence of crime in cases, some of what we do is we will send those documents out for forensic testing for fingerprints, for DNA, to a lesser degree for handwriting analysis. If we see some handwritten notes on the document and we need to try to figure out whose notes they are, we send evidence out for forensic testing. Let's assume that forensic testing is ongoing, is in process, is midstream. Do we have to put an absolute stop to it right this minute? Because Judge Cannon said, I am enjoining, in other words, putting an immediate hold on all investigative efforts in this criminal investigation that arose from the seizure of the evidence of crime that the FBI found at Mar-a-Lago. That, as a former career prosecutor, is not something I ever want to do. If a judge tells me to do it and the judge has lawful authority and we don't appeal the judge's ruling, then we're stuck with it. We have to abide by the court order. But boy, if I were in any of these meetings debating on whether to appeal this order, I would vote in favor of appealing it. Another consideration that the executive branch is going to have to consider is, does Joe Biden now waive executive privilege with respect to all of the stolen documents that were seized from Mar-a-Lago? I don't think he has done that yet, and I don't think he would have felt compelled to do that because there was an argument that Donald Trump can't even lawfully have a special master appointed to review executive branch documents he stole. So there was really no need for Joe Biden to waive executive privilege, but now there might be a need. So would it impact the judge's order or her future decision on whether a special master should be reviewing these documents for executive privilege if Joe Biden now affirmatively waived executive privilege for the items that were seized from Mar-a-Lago, which I don't believe he has technically done yet. He's waived executive privilege in other settings and with respect to other documents, like stuff that went from the National Archives over to the January 6th committee. So that's something else that I think the executive branch is going to have to decide. One of the small bright spots in the judge's order is that she said, well, I'm not going to order that you stop assessing the national security damage that Donald Trump has potentially done to our nation by stealing and unlawfully concealing and perhaps sharing, we don't know, these documents. The assessment by the Office of the Director of National Intelligence, that can continue to see if we can, save the lives of overseas assets, to see if we can mitigate the damage Donald Trump has done to our safety and our national security. Well, thank you, Judge, for throwing us that bone. Yeah, you can see that I am pretty critical of the judge's decision to grant a special master and to stop dead in its tracks the Department of Justice's criminal investigation of Trump and company as a result of the seizure of these documents. Boy, do I disagree with that approach. And as I say, I hope the Department of Justice will seriously consider appealing this, because this should not stand, in my opinion. Second story. Donald Trump held yet another hate rally in Pennsylvania, and he announced in his most aggrieved tones that during the search of Mar-a-Lago, they even searched my 16-year-old son Barron's bedroom. What an outrage. How vicious. What a tragedy. What a travesty. That was unlawful. That's a bunch of nonsense. First of all, let's assume he's telling the truth, never a safe assumption with Donald Trump, and that the FBI did search Barron's bedroom. You know what the FBI was authorized to search by the judicially approved search warrant? The residence at Mar-a-Lago. They were not permitted to search guest rooms, right? Rooms where hotel guests might be staying. but they were lawfully authorized to search the residence. That includes bedrooms. So on the off chance that Donald Trump is telling the truth for a change and the FBI searched Barron's bedroom, they were lawfully entitled to do it. Here's the other thing I'll say. We execute a lot of search warrants every year on the homes of individuals, on the homes of targets of a criminal investigation. If criminals could thwart law enforcement efforts by hiding evidence of their crimes in their kids' bedrooms, that wouldn't make a lot of sense, would it? No. Do you know how many times, friends, I was involved in an investigation and a search warrant was executed and we would find, for example, guns and kilos of cocaine hidden in a stroller in a baby's room. And guess what? The baby didn't put it there. The target of the investigation put it there. That's why when we are applying for search warrants, we make sure we seek permission to search every place evidence of crime could be concealed or could be held, including kids' rooms. So this is Donald Trump lying, putting disinformation into the heads of his supporters, and trying to continue to whip up anti-FBI sentiment, anti-DOJ sentiment, anti-executive branch sentiment. You know, he is trying to raise people to anger and, by inference, potentially trying to inspire them to violence. We've seen this movie before. On January 6th, go to the Capitol and fight like hell, or you won't have a country anymore. Now get down there and stop the certification, for which his foot soldiers, the people who listen to his commands, are being locked up. They're being imprisoned. One was just sentenced to 10 years in prison for breaching the Capitol and assaulting police officers. And tomorrow, Donald Trump has a tea time. So at his most recent hate rally in Pennsylvania, this was just a bunch of nonsense that he continues to offer to his supporters in his, never-ending attempt to fool the gullible. And let's take on a third and final story. And this one has me frustrated and, truth be told, angry. And it has to do with how the Department of Justice is handling the fact that a former president, Donald Trump, has information about how our national security was compromised, and they don't seem all that determined to extract that information from him. Early this morning, I put pen to paper. I guess I didn't put pen to paper. I put finger to phone. This coming from a guy who still does everything on dry erase whiteboards and legal pads. So yeah, I guess I put finger to phone, and I tweeted this morning trying to deal with my own rising frustration. And here's what I said. If any other former president, Carter, Bush, Clinton, Obama, had information that could assist with a national security breach or threat, they would promptly meet with executive branch officials and provide that information. Not Donald Trump. Trump knows precisely who he showed the top secret documents to, who he shared them with, who he gave them to, yet he continues to conceal that information from the executive branch, leaving our intelligence and law enforcement communities scrambling to try to figure it out and assess the damage. And as far as we know, the executive branch has not demanded a meeting with Trump to confront him and insist he provide information that could help mitigate the national security damage, that could help protect the American people, nor have they subpoenaed Trump to the grand jury to compel him to provide that information, nor have they arrested him, even though they have probable cause plus to do so, as an incremental step to obtaining that information. This inaction makes no sense from a law enforcement perspective or from a national security perspective, or from a justice perspective. It makes no sense. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.
Justice matters. Justice matters now.